Everyone. Joining us now is Alissa Nann of counsel to Foley and Lardner. She's actually physically in the New York office today.
Rarity.
But Alissa is a member of Foley's bankruptcy and business reorg practice. And listen, she's obviously well thought of. She's been recognized as one of the top leading U.S. bankruptcy and restructuring lawyers. And she's also been recognized by the super lawyers as a New York Rising Stars list. That is not an easy list to get on. So we're very fortunate to have Alissa joining us today, talking to us about hotel receiverships. Take it away, Alissa.
Thanks so much, Steve. And I just want to say thank you. This is my first time at this conference, so I'm excited to be here. My partner, Cliff Rissman in Texas, who I think a lot of you are familiar with, invited me, to join you all and said it was a nice group to speak to. So I always am happy to jump at those opportunities. So as Steve said, I am a member of the bankruptcy practice group at Foley. I do a lot of work with restructuring and distressed assets, and also represent fiduciaries like trustees and receivers. I've represented a hotel in bankruptcy before, and obviously with COVID and everything that's been going on, we've seen an uptick in hotel receivership. So I've been working with Cliff on a number of those. So this is really going to focus on as we said, the hotel receivership 101. And Taylor, we can jump right into it. So starting off with qualifications, who can be a receiver? You'll hear me say this a lot throughout this presentation, that a lot of things really depend on the state. It really depends on the state that you're in. Some states require receivers to be, registered. There's a list that lenders can choose from if they want to appoint a receiver. Some states you just have to be, a citizen and a resident of that state. Some states you have to do training, some states you don't. So it really depends on what state you're in. Some states require a receiver to be an individual person. Some states it can be an entity. So it totally varies from state to state. Typically in states where registration is required, the practice is you pick a receiver off the list of registered receivers. However, if everything's consensual and a lender and a borrower agree on who they want to act as receiver in a particular case for a property, courts often will grant that if it's consensual and everybody agrees that that's the right person. You can go to the next slide. Usually for whether you need to be registered in the state or even if you don't, there's sort of two key things is ethics and conflicts. You need to make certain disclosures to the court, even if you don't have to pre-register, about, that you have no conflicts with respect to this particular property. You don't have an interest in it. None of your relatives work there, et cetera, et cetera. You're not a lawyer working on, this case. And then ethical disclosures in terms of, background questions about, if you had arrests, are there any criminal issues, things like that. If you do need to register, most states require just kind of your basic personal information, name, social security number, personal and business contact information, things of that nature. You can go to the next slide. And I just gave two examples of how it is in different states. New York, for example, where I am, is one of the more onerous states to require, put receivers through to get on the registry here. You have to register, you have to do a training, you have to re-register every 2 years to stay current on the list, as well as make some, the sort of disclosures about your personal background and ethical, any ethical disclosures that you need to make. You can go to the next slide, please. And then, for example, in Texas, there is no registration requirement. You just need to be a citizen and qualified voter in Texas and actually live in Texas or maintain a residence in Texas during the course of your receivership. And then the couple of bullets after that, those are kind of basically common in every case. Again, they can't have a conflict. You can't be a party interested in the case. And most courts require the receiver, once appointed, to post a bond. We'll talk about that a little further, and basically take an oath to, they're becoming a fiduciary of the property, so they must make an oath to perform their duties in good faith. You can go to the next slide. So the process, how does a receiver get appointed? So most often the loan documents will provide that, upon an event of default, one of the remedies is that the lender has the right to seek appointment of a receiver. That's how a lot of these things are playing out these days. So after a default, the lender can file a petition, a foreclosure petition with the court, and as part of that case, will seek the appointment of a receiver if that's one of the remedies they want to exercise. The receiver is then, appointed at the lender's request. You can go to the next slide. Typically, these things often are consensual. I mean, a lot of this stuff ends up being pre-negotiated. If the lender has the right to seek a receiver, there's usually a discussion with the borrower about, that's what's going to take place. Will they consent in advance? Try to work out, terms so that there's a smooth transition on the property. Making sure that the borrower is aware that this is happening and agrees, they'll be required by order to cooperate with the receiver, but it's always better in practice to, try to work out the transition in advance. So often these things are consensual, and really the only leg to stand on legally is if the borrower contests that there is a default. So if that's not in question, they can still contest the appointment of a receiver, but there's really not a good legal basis to object to it if it's a remedy under the loan agreements. And the lender typically has a lot of influence in the selection of the receiver. As I said, if there is a registry in a particular state, the lender, if they've got a particular person off that registry, they can, seek to have that person appointed. And again, if it's consensual with the borrower, the court usually just kind of rubber stamps the selection of the person. Sometimes, depending on, if there's a flag, some of the franchisors want to know in advance who the receiver is going to be, and also who the management company is going to be, if there's going to be a change of management company. So always good practice to, discuss with the franchisor, obviously, just if there's going to be a receivership, foreclosure and a receivership, but in particular, certain of the flags we've seen want to know specifically who the receiver is going to be in advance and want to have some control over that. You can go to the next slide. So the receiver is appointed as a fiduciary to the property itself and the assets. It's not, he or she is not acting on behalf of a particular stakeholder in the case. Their duty is to maintain the property. And sort of the main document of this whole thing is the receiver order. It's the Bible, so to speak. It sets forth all the rights, duties, and obligations of the receiver. Often the lender will have a form of receivership order that they like to use that kind of, sets forth everything that the receiver is able to do and required to do during the course of the receivership. It'll set forth, we'll get into that in the next slide, but I mean, it's got everything in it, everything that needs to be turned over, and all of the things at the hotel that the receiver is going to take control of. You can go to the next slide. Basically, you want the receivership order to be as fulsome as possible so that you don't have to go back to court to seek additional relief if things come up that you weren't contemplating at the time that you filed the petition seeking the appointment of a receiver. You want to make sure to include that the receiver will take custody and control of kind of like the kitchen sink, anything that you can think of, including all physical assets, electronic records, things like keys, passwords to get on systems, in addition to some of the more, obvious things that we mentioned here. Any assets or any records of the property and of the borrower relating to the property will, go to the control of the receiver. You can go to the next slide. So books, records, information technology, as I mentioned, is a big one now, since obviously so much of the records are now, everything's online. All the deposits, credit card accounts, basically all revenue sources and deposits and refunds become the property of the receiver during the course of the receivership. You can go to the next slide. The licenses and contracts are a big issue too, particularly liquor licenses at a certain hotel. If you can, if they are transferable under the law of the state, the receiver can basically step into the shoes of the borrower and use the liquor license, so long as that's so ordered in the receiver order. In some states, it's not transferable, even if the order can say so. If you can have a form order that includes the transfer of liquor license as applicable, but it's not transferable under state law. So the receiver may have to, once it gets into the property, get in there and apply for its own licenses. Collective bargaining agreements are obviously a big one. If there's a union at the hotel, it may require a negotiation or a signing on by the receiver of an existing CBA. And also franchise agreements. Some flags may require the receiver to enter into a new or a temporary franchise agreement. It depends on the franchisor and their preference, but we've seen that a lot now, that some of the franchisors want the receiver to sign on to a new agreement. You can go to the next slide. So the receiver order basically provides that, the receiver is going to manage and operate the property. A key thing is to require the borrower and the guarantor to cooperate with the receiver, turn over all the assets, turn over all the books and records, provide all of the physical and electronic records, but also to, assist basically in giving access. Usually once a receiver order is entered, you try to set up a meeting with the borrower to say, can you meet with the receiver and the new management company, if there is going to be one, the next day or something, just to go through everything and make sure the receiver's got all the information that he or she needs to get up and running. Hopefully that happens. Sometimes it doesn't. That's where things get interesting. But that's why it's good to try to have conversations with your borrower in advance and make sure that they're informed about what's going on, and hopefully ensure cooperation on their end. The receiver order should also require the borrower to provide an accounting to the receiver, and the most recent financial reports and records, so that receiver's got a good foundation for kind of where things are at with the property. Because a receiver order will often provide, or a court will require, that a receiver's got to file a report with the court within the first, typically 30 to 60 days once the receiver's appointed, so that everybody can see, where things are at and what the receiver's done since they've gotten appointed to the property. So it's important to make sure that they've got the most recent records and accounting, so that they can, get up and running with a good picture. You can go to the next slide. The receiver order should also prevent the borrower from interfering with the receiver. It should require them, as I said, to turn over and cooperate and stop them from any sort of interference with respect to the property. A key point is also including payment of receivership fees and reimbursement of expenses, which will come from the revenue generated by the property. And if that's not sufficient, to get advances from the lender. So those are also key conversations to have before the petition for the receiver, to negotiate, how is this going to work? And in addition to what are the fees, what are the protective advances that we need to both pay the receiver and the cost of running the hotel if the revenue isn't sufficient. The receiver is usually not required to, actually not usually, the receiver is not required to, if there are insufficient funds generated by the property, the receiver isn't required to come out of pocket to pay operating costs, but it can. Sometimes, depending on how the lender wants to advance funds or provide a kind of like a startup cushion, working capital to the receiver, to pay, any defaults. I mean, if the receiver is coming into a property where there are threats of, utilities being shut off or franchise fees haven't been paid and there's a threat of the flag being pulled, it's really a discussion with the lender and the receiver of, who is the lender going to pay those costs directly, or is the lender going to give the receiver a working capital cushion to satisfy those things if there are things that need to be cured immediately to make sure that the hotel, can continue to operate. And with respect to working capital and advances on a going forward basis, the receiver order will often provide that, the receiver can use revenue, up to a certain dollar amount to pay regular operating costs. But if it gets above, depending on the property, if it gets above $50,000 or $100,000 or whatever the case may be, the receiver needs approval from the lender to spend those revenues. There'll often also be a provision that says, if there's a cushion above X dollars, the receiver will make interim distributions to the lender to pay down the loan default. You can go to the next slide. That's basically what I just covered. So the receiver is also required. I talked about the initial receiver report, usually 30 to 60 days after appointment. The receiver is required to file an initial report, and then usually monthly reports are required after that. Sometimes, there's different time frames. Sometimes it's 45 days or every 90 days, but typically there's a monthly report required that just, it's mostly financials. If anything, unusual has occurred at the hotel, or there's, change of management team or something like that, something substantive to report to the court. But usually it's just financials and sort of, where the hotel is at. You can go to the next slide. The receivership order will also provide that the receiver's able to employ certain professionals, including a management company. Often we see a receiver will retain a management company that he or she either also works for or with, so that there's familiarity there, and the receiver, knows the team who's going to come in to handle the transition. And the sort of the roles there are, the receiver is the fiduciary for the property and reports to the court, and makes, decisions regarding the receivership and the operation of the hotel. But the management company is still running the day-to-day operations of the hotel and reports to the receiver regarding those day-to-day operations. There is a separate written agreement between the management company and the receiver. Also something that's pre-negotiated typically. Sometimes the lender will require approval of the management agreement, particularly because, if there are operating expenses, and obviously the fees of the management agreement are going to come from the hotel proceeds, and then the lender is, going to have to pay any deficiencies there as well. So typically we see the receiver and the management company negotiate that in the first instance, and then, the lender wanting to, provide comments, if any. You can go to the next slide. The receiver is required to maintain kind of all the things that the borrower, would be required to maintain as well. Insurances, the liquor license we mentioned. The receiver will need to do things like open new bank accounts, get a tax ID number, and be responsible for paying taxes, filing tax returns, and all of the obligations that the borrower would have. Selling the property is also depends on the state. Some states, a receiver in this position is not allowed to sell property. In some states, a receiver is, and in some states it is, with the condition that it requires notice to the borrower and the consent or the consent of the lender, and it's always, if it's an action being taken by the receiver, will require court approval. So this is an interesting one. I've seen this in receiver orders in states where they're not allowed to sell the property. So it's always a trick to, just make sure your receiver order is consistent with the law, or just be aware that, just because it's in the order, it doesn't necessarily mean, it's a go in the state. So just something to be aware of. But typically, if the property is going to be sold, what would happen is it wouldn't necessarily be sold by the receiver. It would be, marketed outside of the receivership, and then the receivership would just terminate once the sale is effectuated. You can go to the next slide. I mentioned a franchise agreement. The receiver, in the receivership order, the receiver will be authorized to negotiate with the franchisor and enter into a new agreement. Again, that's usually driven by the franchisor if they want that new agreement directly with the receiver, which some of them do. And then an important one for the receiver is the receiver's liability relating to any decisions made or actions taken during the course of the receivership, is that the receiver is not liable unless they're acting with gross negligence, willful misconduct, or they engage in fraud. A receiver, to effectuate the receivership, the receiver is required to take an oath as a fiduciary, and also most of the time is required to post a bond. Again, that depends on the state. Sometimes, there's not a bond requirement on the state per the state law, but the court will, ask a receiver to post a bond anyway. Sometimes that depends on whether, the receivership was contested or not by the borrower. If the borrower, is contesting the default and saying they're going to, take the property back, sometimes the court will then require the receiver to post a bond. So it really just depends on the state and the context of the case. You can go to the next slide. And I know I have a lot of content here. So once the receiver is appointed, you really need to get in there. This is where your management company is really key to kind of just, take a good look-see, make sure you've got access to all the systems, confirm all of your insurances, document everything, take videos, take photos, so that you have a good, documentation of the state of the hotel. Once you're taking it over, you open your new bank accounts and make sure, all of the cash is flowing, all the credit card receipts, and just kind of, dot your I's and cross your T's to make sure you've got access to everything, or document any issues that may require, conversations with the lender and the borrower, or if necessary, to go back to the court to have the borrower be directed by the court to cooperate, provide access, etc. You can go to the next slide. This is sort of, more of the same, excuse me, of action items to take when you first come in there. I want to leave a couple minutes for questions, so you can go to the next slide, Taylor. This is talking about transition as well. Sometimes the existing management company will stay on, or more often than not, the receiver will hire their own transition company. So again, making sure that transition is happening smoothly between management companies to transition all of the assets and the hotel proceeds. The second bullet, established process with lender for protective advances. That's something that I touched on. That's usually pre-negotiated of, when will the trustee request protective advances, at what dollar amount of working capital cushion needs to be there before a request is made for protective advances. Obviously, those things can change along the way depending on how the hotel is doing with respect to cash flow. You can go to the next slide. And then the receivership ends either if the foreclosure is granted and the hotel goes into REO, if the hotel is sold, or the receiver can be discharged for a variety of reasons. Most common is if the default is cured by the borrower, then there's no basis for the receivership anymore per the loan agreements. That's often the time that we see a discharge of a receiver. And then upon the ending of the receivership estate, a receiver is required to file a final report with the court. And that is the end of the slide. And I'm happy to answer any questions, although I know I didn't leave much time for that.
That's quite all right, Alissa. Wow, very insightful information and a nice step-by-step process. Loved your tips at the end. A great checklist for people. Thank you very much. So I have a couple of questions. I'd like to remind the audience to submit yours to the chat. I know we've got one coming in now, but before we get to that, so when I'm just trying to think through from the borrower's perspective, you've got these receivers on this list and you've established criteria for them to join, right? To become a receiver. And it sounds to me like it might be pretty cushy between the lenders and the receivers at some point. Can the borrower ever object? I know you said they can object on a certain basis, but can they ever object based upon the criteria, right? That the receiver doesn't actually meet the criteria. Have you seen that happen before?
Yeah. And a court will, so just because you're on the receiver list doesn't mean, you're solid, right? You still need to file with the documents when the request is made to appoint a receiver. The receiver is required to have a receiver affidavit, which usually they've attached then their experience, their CV, what properties have they managed in receivership or outside of receivership that were in distress in this market or similar hotels in other markets. So they've got to show their experience and that they're qualified to do this. It's not just the case, although again, depends on the state and depends on almost the court within the state. Sometimes it's almost the receiver is buddies with the judge kind of a thing too. The judge, I know this person, they're good, whatever it is. So we've seen that too, depending on the court. But no, the receiver needs to prove up their bona fides and demonstrate that they've got the ability to do this and they have experience. And sure, a borrower can say, you can't appoint your cousin Bob's wife or whoever to be the receiver. So sure, that can come up.
Yeah, it seems a little cozy. It's almost like you mentioned, the judge and the receiver. It's kind of like the guardians, right? Getting appointed by judges and guardian ad litem.
Yep.
Because this really is a guardianship, right? I mean,
exactly.
You feel it back, right?
Yeah.
Yeah. Well, okay. Well, so we've got a good question in the queue. What are some common pitfalls when parties are outlining the receivership agreement process? What have you seen that we've learned from our mistakes?
So I think, when I said the receivership order is really, the Bible, I mean, I think the most common thing is, something that's not included, like a common transition item that, the borrower is not required to turn over X, or the borrower, you forget a step in the process of really a transition issue, or, the receiver is not entitled to take control of Y, and then when they get to the hotel or the property and then it's not in the order and you need to go back to court to add that particular relief. So you really want to be as inclusive as possible, itemize things specifically, which is why it's important, the lender will know the property or the management company will know the property and sort of what's there. That's key to include in the order, but then also to include, other sort of expansive language to kind of be like anything else. You try to be as specific, and these orders can be like 30 plus pages because you really do want to be specific as possible, and then also try to cover your basis. So I think the most common thing we see is something that is key to the turnover and the transition is not included in the order, and then you need to go back and seek relief, and that takes time, right? And when you lose time and you don't have the ability to smoothly transition quickly, that can be damaging to the property.
In that regard, very thorough answer. Thank you. In that regard, in your experience, how long does it take a receiver to get up to speed? Assuming they're qualified, right?
Very quickly. I mean, especially, you're welcome. Very quickly, especially, I mean, this is where a good, a good management company, a good management team who works with the receiver is sometimes more important than the receiver themselves, because they're the ones who are really going to jump in, talk with the existing employees, get the download, who are going to be on the ground. I mean, the receiver will be on the ground too, but they need a team, he or she needs a team around them to kind of get up to speed on all the different facets here, especially if there's a union, especially if there's issues with transition, if it's a state where the liquor license isn't transferable, that can take a really long time to get a new license. So you need to have, a team in place who can kind of take different action items and run with them. But yeah, usually we have things lined up where, if we have a receiver hearing on a Monday, you've got folks on standby to go to the hotel that afternoon, right? If the order's entered that day, or they know, it may be entered, the judge is going to enter it tomorrow. So you're on standby basically from the time of the hearing going forward to make sure you can get there ASAP. And usually the receiver will go in advance. I mean, this is why, it's not a secret, right? So the receiver can go in advance to the hotel, hopefully talk to the owner or whoever the manager is on the property in advance to say, hey, can you just give me the scoop on what's going on? If it's a contested thing, then that's not, that makes it a little more challenging, but usually the borrower knows this is coming and, either wants to work with you or resigns themselves to the fact that it's happening regardless of how they feel about it. And so usually you can at least get kind of like baseline information that's helpful to issue spotting in advance. So you can jump right on that stuff when you get in.
And back to the borrower again, are they entitled to the stream of information coming from the receiver to the
That's
lender?
why the reports are required.
Because so the borrower has access to that as well.
Exactly.
Okay.
Yeah, I should have mentioned that. Yeah, it's more it's not for the court, it's for the borrower to say.
The borrower.
Yes.
Yeah. And the lender, I assume, but the borrower has a feel.
And the lender will work with the receiver. I mean, the lender is going to get more real-time information, but the reports are really for the benefit of the borrower so that they're informed and they get all the information about the hotel financials and they can see what's going on.
Yeah. Okay. Yeah. And then, when I first heard you say, or saw in your outline that, the receiver can hire their own management company, I thought, well, isn't that cozy? But I can also see the economic efficiencies that come from that. And I assume that's the reason they've decided that outweighs the risk of a conflict, right?
Yep, exactly. Yep, they can work, right. They're used to working together. They know exactly who at the management company does what, where, and if it's a national management company that can have other resources to bring in, or if it's local and they know the area. I mean, there's benefit, depending on what the property is and what it calls for, it is more efficient to have the receiver work with a team that he or she knows.
Okay, so here's the last question I have, I think. But we talked yesterday with Cliff about, who owns, who do the employees actually work for? Who owns some of the sales data, right? Contacts. And Cliff said, well, at the end of the day, everybody can go on LinkedIn and find out who's who these days, right? So it's not that. I think he called it a toothless tiger, which I thought was great. But since this receiver is coming in a temporary situation, but they're still going to be focusing on sales, right, with their management company. But do these agreements that you talked about, do they go so far as to decide who owns the soft assets that get developed, right? The customer service lists, the group meeting lists, things like that. Do they go that far?
The order does not get into that. I mean, so the borrower owner still has title to the assets of the hotel. That's a very good question. But yeah, if there's like proprietary information that's developed. So the management agreement between the receiver and the management company will get into proprietary information that the management company uses and puts in place at the hotel. So I think if it's a new management team coming in and they're using that, they have proprietary programs or things that they put into place. I mean, that the management agreement would allow the management company to dictate if there are like soft IP assets that are their proprietary information. I mean, one of the realities of this too is if this property is going to be sold, which it often is, that's the goal, right? Is to sell this, that the lender doesn't necessarily want to own this hotel, right? Then the management company who's coming in with the receiver often stays on with the new purchaser, right? So that all those systems and things would stay in place. Not always, that, doesn't have to be the case, but, I think that's I would say more often than not how it plays out. So it doesn't actually get to that.
Yeah, probably a good thing.
And then they stay. So.
Yeah, that can be contentious, I'm sure,
Yeah.
at some point. I was just curious if it was figured out at the beginning.
Yeah, no, it's a good question.
Yeah, Tej will ask another question about the real estate, because often the real estate, right, might not be, it might not be included in the, well, anyway.
It's still the borrower's property unless and until the foreclosure is granted by the court, and it goes into REO. So the receiver is just a fiduciary for the property, for the asset itself, but the borrower still has title until the court determines, on the foreclosure action, that it grants the foreclosure. Then it goes to the lender.
Yeah. I was just curious if you've been in situations where the real estate had a separate ownership group, and the building of the hotel itself perhaps is on a lease. It would actually, it just wouldn't impact the real estate group as long as the lease remained current, right?
Yeah, but the receiver never takes title ever, right? It's just a fiduciary for the asset. So if the ownership is separate from the borrower, then it still stays whoever the title owner is.
Yeah, very good distinction. Tej, great question as usual. Thank you very much. Alissa, thank you very much for joining us. We'll send a glowing report to Cliff.
Excellent.
And we hope to see you again at one of our conferences in the very near future.
Thank you. I appreciate your time.